Hi, everybody. Thank you so much for being here today. My name is Grace Carson. I am Yavapai and Chiricahua Apache, and I am a Skadden Fellow here at Tribal Law and Policy Institute. I will be giving this presentation on part evolution of healing wellness courts, and then if my fellow folks who are also helping present would like to introduce themselves and maybe go to the next slide, that'd be great. Maybe we could start with Alyssa.
Hi, everyone. Thank you for joining us today. My name is Alyssa Harold. I am a wellness court specialist with TLPI, specifically developing the peer-to-peer learning program for tribes to help one another with their healing to wellness courts. And we look forward to talking about the evolution of programming with you today.
Thanks, Alyssa. And hi, everyone. My name is Catherine Rotana. I'm a tribal law specialist with the Tribal Law and Policy Institute. And I work with both the Tribal Healing to Wellness Court project as well as the Tribal State Collaboration project. So I'm happy to be here with you all today. And I will be talking a little bit about the evolution of healing to wellness courts and the different intergovernmental court collaboration models. Thanks. And I'll pass it over to Grace.
Thank you so much. So this presentation will kind of start with looking in the past 25 years of what healing to wellness courts have looked like and how it began to be found and started. We will then kind of dive into what the current updates are for healing to wellness courts, and then we'll end looking forward and what we can anticipate healing to wellness courts to look like moving forward. So tribal healing to wellness courts are tribal adaptations of drug courts. So their development begins, of course, with the drug court movement. The drug court movement began in the late 1980s in response to the growing number of drug-related court cases and the resulting overcrowded jails and prisons. For many, it became clear that the standard law enforcement and corrections policies did not have the impact on drug supply and demand that the proponents of the war on drugs had hoped. The judicial practice of sentencing offenders who suffered from substance use disorder and addiction to treatment as a condition of their sentence or probation fell short as well. Consequently, the drug court approach has been developed to process substance use-related court cases. This approach departs from the regular court practice by systematically bringing treatment to the criminal justice population entering the court system. The drug court approach anchors treatments with the authority of a judge who often, with team input, holds the defendant or offender personally and publicly accountable for treatment, participation, and progress. What began as a grassroots initiative, drug courts have now spread across the United States and are nearly in 20 countries. Teams of judges, prosecutors, public defenders, treatment providers, law enforcement essentials, probation officers, case managements, and a host of other community members use the coercive power of the court to promote abstinence and to alter behavior. This is accomplished through a combination of intense judicial supervision, praise for progress, sanctions for noncompliance, random drug testing, comprehensive and phased treatment, aftercare programs, and other ancillary human services. So then we look forward toward how adopting drug courts with Indian country has happened. After learning of the drug court movement, tribal leaders and judges expressed interest in its potential benefits to their nations. They were particularly interested in how it could help address the severe alcoholism and its associated crime prevalent in Indian country, especially in a non-adversarial nature. As interest in this approach grew and was studied further, both tribal and federal advocates realized that the drug court concept could have a positive impact on Indian nations if it was modified to meet the specific needs of Indian nations. Consequently, in 1997, the Drug Court Program Office, otherwise known as DCPO, which is now since merged with the Bureau of Justice Assistance, BJA, developed a special program to assist Indian nations to plan and implement a drug court within tribal governments. DCPO charged the National Association of Drug Court Professionals, and this is where we're going to get a bit acronym-y, I apologize, but NADCP, with the task of creating a culturally sensitive training program that would meet the needs of the initial 22 Native nations that had been awarded drug court grants through the DCPO. In August 1997, NADCP, in collaboration with DCPO, more acronyms, and a group of individuals with tribal court and substance use expertise helped design an adapted curriculum for tribal court training sessions. The first of a series of tribal-specific training sessions was held in Stillwater, Oklahoma in September 1997. These tribal drug court training sessions served a vital role in assisting tribal representatives from each community to adapt the drug court concept to meet the needs of their individual nations. At subsequent training sessions, representatives from tribal courts, tribal councils, law enforcement, treatment providers, tribal and community memberships, and various human services organizations came together to develop an action plan for drug court development in their individual communities. And as we know, the first 4 healing and wellness courts were Blackfeet Alternative Court, Fort Peck Tribes, Hualapai Wellness Courts, and Porch Band of Creek Indians. Though there were many trial and errors from these initial courts, they are the tribes that set the foundations of healing wellness courts today and how we were able to develop the courts today. The birth of healing to wellness courts came early on in the development of their drug court programs. So when this happened, many preferred a term other than drug court to be used to describe their rendition of the drug court approach. Tribal representatives felt that the term needed to clearly incorporate alcohol abuse cases because alcohol is the predominant, or at least was at the time, predominant substance use problem in Indian country. And they also wanted a different name to culturally connect to the tribal community to allow it to take ownership. So rather than just adopting drug courts, they wanted it to be able to create its into a new thing that was culturally sensitive and was informed and led by tribes and tribal values and concerns. The name Tribal Healing and Wellness Court was coined by a tribal advisory group who convened to develop publications specifically concerning tribal drug courts. Initially, tribal drug courts were referred to generally as tribal wellness courts. However, members of the advisory group learned that some tribal drug court personnel were concerned with that term, with the term that wellness might imply that the participants had achieved wellness rather than striving to achieve it. So that's why the name had been changed healing to wellness courts. But ultimately, there are still multiple names used for by different tribes to describe healing to wellness courts. They wanted to use healing to wellness courts as a name because they wanted to understand that it incorporates both healing and wellness, and that the program's effort to promote wellness for the program participants as an ongoing journey. Since their inception, tribal healing to wellness courts have spawned a new generation of drug courts, and more importantly, a new beacon of hope for the continually devastating effects of alcohol and drug use in Indian country. In 2011, the Department of Justice and the Department of Interior and its Tribal Law and Order Act report on tribal justice systems identified tribal healing to wellness courts as a model for alternative to incarceration. Tribal healing to wellness courts were specifically recognized as an effective tool that permits tribal nations to employ culturally based strategies. These findings were reiterated in the 2013 Indian Law and Order Commission report, which stated that tribes are specifically encouraged to develop and enhance drug courts, wellness courts, and to develop data that further inform the prioritization of alternatives to incarceration. As we know, tribal healing to wellness courts are not simply tribal courts that handle alcohol and drug abuse cases. A wellness court is a special court docket with the responsibility to handle cases involving alcohol or drug using offenders through an extensive supervision and treatment program. A tribal healing to wellness court epitomizes a justice system that applies the drug court concept in a manner intended to meet the needs of the community, particularly the need to address the devastation caused by alcohol, other drug use, and crime. The design of a healing to wellness court program is developed at the local level to reflect the unique strengths, circumstances, and capacities of each tribal nation. The first healing to wellness courts were designed to serve either adult or juvenile participants. We'll talk a little bit more about that later. And then later, family wellness courts, utilizing the family court docket, became a focus given the generational impacts substance use and crime has had on tribal families. Currently, tribes have the opportunity to design a tribal healing to wellness court that accommodates their community's needs and judicial philosophies. And we will discuss more about how tribes are currently utilizing the opportunity later. Whether an adult, juvenile, family, or any other variation of a tribal healing to wellness court, all are guided by the 10 key components, the fundamental essentials of the drug court concept. Fashioned after the 10 key components initially formatted for state drug courts, the Tribal Healing and Wellness Court 10 key components were crafted to reflect tribal notions of healing and wellness, particularly the concept of a healing to wellness journey and the collaborative effort involved in supporting such a journey. The Tribal Healing and Wellness Court 10 key components are the basic operational characteristics that all healing to wellness courts should share as a benchmark for performance. They are also now used by BJA in consideration of drug court grant awards. So the big point here is that tribes were able to create their own key components rather than simply just adopting drug court components, making it their own way of evaluation and implementing healing to wellness courts. You can go to the next slide. So here we're going to discuss a little bit the unique role and importance of tribal justice systems and tribal courts, specifically talking about how healing to wellness courts are a practice of tribal sovereignty. In order to fully appreciate the challenges and opportunities that tribal healing to wellness courts face, it is helpful to understand the unique role and importance of the more than 300 tribal justice systems in the United States. Tribal courts and justice systems are critical components of the tribal government. They are empowered to resolve conflict and controversy. In the absence of judicial institutions, unresolved disputes and disagreements would interfere with the safety and well-being of the tribal community and efforts towards nation building. Prior to European settlement in the Americas, Native people have practiced various forms of meaningful and productive conflict and dispute resolution. Tribal member participation in debate of issues and in defense of the alleged was not just allowed, but it was expected, such as due process. Unfortunately, these tribal methods were unfamiliar to the settlers and were often discounted and even discouraged. The first modern iterations of tribal courts were the Court of Indian Offenses or Courts of Federal Regulations. These are known as CFR courts. CFR courts were established by the Department of Interior in 1883, in part to handle less serious criminal actions and resolve disputes among tribal members. However, many of the judges were non-Indian Bureau of Affairs, BIA, superintendents, with express objectives of assimilating Native people into Western society and abolishing barbarous practices such as dances. Not until 1934, with the enactment of the Indian Reorganization Act, were Indian tribes allowed to exercise their inherent sovereignty to establish their own justice codes and operate court systems enforcing those laws. The act authorized tribes to organize and adopt constitutions. However, most of the tribally enacted constitutions were templates requiring Secretary of Interior to approve for many tribal government actions. Nevertheless, despite its flaws, the act is considered a success in providing a framework for and first steps towards expanding tribal government. Some Indian tribes chose not to organize under the act, and some still operate as CFR courts, some of which remain in existence today. Today, tribal justice systems are diverse in concept and character and are at various stages of development. While some are quite elaborate, others are just beginning to develop a modern judicial system within the context, conditions, and circumstances of their individual nations. Some tribes prefer the adversarial process, while others have determined that traditional dispute resolution is more important. Many courts apply large bodies of written or positive laws, and others apply custom and tradition to address controversy and settle disputes. At all stages of development and for every type of judicial procedure, tribal justice systems require resources, support, and provisions similar to that of their state court counterparts. The success of tribal court is essential to not only dispute resolution, but also to the promotion of tribal sovereignty and self-government. Effective tribal courts support economic growth, empower the legislative and executive branches, promote peace and community health, and advance tribal sovereignty. This is what healing and wellness courts also seek out to do. Tribal healing and wellness courts are a natural progression for tribal courts as such. as a greater understanding of Indigenous cultures and experiences have allowed for the recognition of and respect to tribal courts, traditional tribal conflict resolution has also gained wider recognition. Alternative dispute resolution has slowly gained traction within the United States as incarceration has been proven to be less and less effective. Drug court popularity stems from its roots as an alternative to imprisoning drug and alcohol offenders. However, Native judicial systems have always tended to focus more on restorative justice, that is, the renewal of damaged personal and community relationships, and reparative justice, which offenders, and this is when offenders make things right for themselves and those affected by their behavior. Today, tribal healing and wellness courts utilize a non-adversarial approach, integrating traditional concepts of healing and community involvement towards healing, rather than punishing their addicted tribal members. Not only are healing to wellness courts a leader for restorative justice systems in the United States, but they're an active practice of tribal sovereignty. Tribal justice has survived in part because restorative justice and their practices of restorative justice. Traditional restorative justice survived assimilative violence, and when we return to it and alter it to meet our current needs, such as we do to healing to wellness courts, we are practicing tribal sovereignty. You can go to the next slide. So we have several updates in healing to wellness courts that are currently happening and some trends that we are seeing. One of those is harm reduction. Harm reduction is a set of practical strategies and ideas aimed at reducing negative consequences associated with drug use. Harm reduction is also a movement for social justice built on a belief and respect for the rights of people who use drugs. Harm reduction incorporates a spectrum of strategies that include safer use, managed use, abstinence, meeting people who use drugs where they're at, and addressing conditions of use along with the use itself. Because harm reduction demands that interventions and policies designed to serve people who use drugs reflect specific individual and community needs, there is no universal definition or formula for implementing harm reduction. However, there are some basic principles. One is that harm reduction accepts, for better or worse, that licit and illicit drug use is a part of our world and chooses to work to minimize its harmful effects rather than simply ignoring or condemning them. It understands drug use as a complex, multifaceted phenomenon that encompasses a continuum of behaviors from severe use to total abstinence and acknowledges that some ways of using drugs are clearly safer than others. It establishes quality of individual and community life and well-being, not necessarily cessation of all drug use, as a criteria for successful interventions and policies. And it calls for the non-judgmental, non-coercive provision of services and resources to people who use drugs in the community in which they live in order to assist them in reducing attendant harm. And we're seeing more and more tribal healing to wellness courts become interested in harm reduction and to begin to implement policies that are rooted in harm reduction in their courts and in their programs. Next, we see that healing to wellness courts have become interested in recovery capital. Recovery capital is conceptually linked to natural recovery, solution-focused therapy, strengths-based case management, recovery management, resilience, and protective factors, and the idea of wellness and global health. There is an added functionality to this concept, however. The resources or capital a person needs depend heavily on the severity of a person's substance use disorder and the resources that they have available. Say a person has severe substance use disorder but little recovery capital, they are more likely to benefit from a professional treatment and post-treatment support services. However, a person with moderate or severe substance use disorder and high recovery capital may require fewer resources to find and maintain recovery. In other words, recovery capital is the total resources that a person has available to find and maintain their recovery. So there's several types of recovery capital. There's personal recovery capital. This includes an individual's physical and human capital. Physical capital is the available resources to fulfill a person's basic needs like their health, healthcare, financial resources, clothing, food, shelter, transportation. Human capital relates to a person's abilities, skills, and knowledge, like problem solving, education and credentials, self-esteem, ability to navigate challenging situations and achieve goals, interpersonal skills, and a sense of meaning and purpose in their life. A second form of recovery capital is family and social recovery capital. These resources relate to intimate relationships with family and friends, relationships with people in recovery, and supportive partners. It also includes the availability of recovery-related social events. There's also community recovery capital. This includes attitudes, policies, and resources specifically related to helping individuals resolve substance use disorders. And then lastly, there's cultural capital. These resources resonates with individuals' cultural and spiritual beliefs. We see a special recognition of this in healing to wellness courts, and we see healing to wellness courts become more and more interested in recovery capital and how that can assist healing tribal members. Next, we have screening and risk assessment, and we're going to have Alyssa jump in here and talk a little bit about that.
Thank you, Grace. So at the start of healing to wellness programs, there was more of a focus on getting individuals into programming with the sense of we want to help everyone. There are not going to be any citizens that are unworthy of redemption, and therefore we're going to give citizens an opportunity to participate in these programs. And while that notion is wonderful and it comes from a place of healing and a holistic approach, as research came out over the last 20 years, it is actually important that individuals are placed in programming at appropriate risk and needs level. So within the last few years, there has been a real push for healing to wellness courts to have validated risk and needs screenings and assessments. And this has been specifically difficult for tribal populations, one in part of funding, because these are expensive tools to become trained in, and then as well as having staff to be able to perform these validated screening tools, because there's a higher level of turnover and changes in programs. A lot of individuals do double jobs while they serve on healing to wellness teams. So there is more need for individuals to become trained in the high risk, high needs matrix. So what we are looking for is individuals who both score out as having high risk, which is going to be someone who is more likely to reoffend if they don't get proper rehabilitative services, such as their housing or their families, their education. And this is something that tribes do really well at, and I think even better than our state partners and their drug court programs, is look at the person as a whole. So when they are able to get these risk screening tools, and that has been a movement in programs as the next piece of evolution, is who is going to be the best fit. And we are also looking for specific data for Native American populations, because currently we are only using data of general drug courts, as we do not have as much information for Native American specific populations. So the overall data tells us someone who needs these more supports will be more successful in programming, because the rehabilitative features are going to apply more to them. And then the needs component is going to be individuals who are substance abuse dependent, as screened by a validated tool such as a SASI or a DAST, who have a moderate to severe substance abuse disorder. So we're looking for those two frameworks. And then additionally, as we move into the evolution of healing to wellness courts, more and more courts adding in cultural assessment tools. And that's something that I think is going to be very helpful. As we know, connection is one of the most preventative factors in healing to wellness courts and individuals coming home to their communities. So not just stopping the addictive behaviors, but replacing it with a positive. So I think the more we add in those cultural assessment pieces and then see how individuals are doing with their services and working with traditional advisors and getting integrated back into the community. That will have more data to support that culture is preventative. We already know that as tribal programs, but overall national data, and that will be supported for more funding in future programs. And that is what I have on screenings. Thank you, Grace.
Thank you, Alyssa. The next update that we have is trauma-informed practices, and Angie is going to chime back in and discuss a little bit about that for you all.
Yeah, thanks, Grace. So another thing we see currently in tribal healing to wellness courts is incorporating trauma-informed practices. And that's where tribes are increasing their knowledge on how to be trauma-informed in the treatment and healing to wellness court processes. There's an increased awareness of not only how personal trauma relates to substance use, but generational and historical trauma as well. And tribes are adapting their treatment according to these updates in how trauma relates to substance use. So it's important to recognize that trauma is more than an emotional response. It has a physical effect and a mental health effect, and that needs to be taken into consideration in a trauma-informed treatment court in general, but particularly for tribal healing to wellness courts because of those additional factors of historical and intergenerational trauma. Healing to wellness courts are actually naturally trauma-informed when you think about the tribal approach of being holistic and healing in body, mind, and spirit, and healing the person in front of you. So just as Grace mentioned earlier in the birth of healing to wellness courts, where wellness is intended for each participant as an ongoing thing, ongoing journey. And Alyssa just mentioned helping everyone by looking at the appropriate risk and needs assessments for each individual. So it really is looking at the person in front of you in a trauma-informed approach. So that's the goal that the tribes are wanting to reach in healing to wellness courts that are trauma-informed, because ultimately a tribe is only as strong as their people are. So it's important to recognize that how trauma can manifest itself in a person, and ultimately the goal would be to also not re-traumatize when there's a tribal healing to wellness court response, because it's intended to be therapeutic. So it's important to understand the background, how it's related to substance use, and then ultimately providing the services in a therapeutic way that's not re-traumatizing. Thanks, Grace. I'll turn it back to you.
Thank you, Angie. Our next update that we are seeing in healing to wellness courts is circle keeping and peacemaking, which I am personally thrilled about because that is my research area. So peacemaking will be explained more in depth in the webinar being hosted on Thursday, the Tribal Healing to Wellness Courts as Restorative Justice. But briefly, peacemaking is a traditional way of practicing restorative justice, and it can be most simply described as a process where people can talk together to resolve conflict. Though, of course, it's not one size fits all, as also healing to wellness courts are not one size fits all. It's a cultural practice that varies with each tribe. Peacemaking is being implemented by tribes in their healing to wellness courts phases, within the phases that focus on community support and well-being, since it's a bit of a mediation process or conflict resolution process. And it mends possible harm caused within a person's community. A lot of people often who participate in substance use can commit harm, just as people who don't use substance can commit harm, but it's an opportunity for those people to come back in their community and to mend harmed relationships with their community and their family members. And then another update we're seeing within healing to wellness courts are gender and cultural considerations. Healing to wellness courts are continuing to adapt new considerations that come along with gender and culture, such as providing specific treatment to women and people who are transgender and more. I'm seeing a lot more workshops being done on that particular issue. I know there was a few last year at the enhancement training, and we expect to see a lot more trainings on that issue as healing to wellness courts want to become more up to date on gender and cultural considerations. And then lastly, have seen through the evolution of healing to wellness courts, variations of different healing to wellness courts. And we discussed that a little bit, but there's several types of healing to wellness courts, including family healing to wellness courts, which we talked about previously. Children and families that are involved in family courts tend to spend less time in foster care and are more likely to achieve unification. So family healing to wellness courts are the tribal version of these family drug courts, and they incorporate culture into their treatments, just as healing to wellness courts do. There's also juvenile healing to wellness courts, which is a comprehensive strategy to support tribal youth on a path towards wellness and recovery with respect to substance misuse. They are similar to adult healing and wellness courts, but a primary difference is that the wellness court team works with youth and their families as partners in all components of the program. The team also works with more stakeholders in the schools. Treatment is also tailored to the developmental needs of adolescents and the unique needs of gender, just as we discussed above. And then we're also seeing veteran healing wellness courts. So tribal veteran healing wellness courts are restorative justice dockets established to respond to the offenses and treatment needs of veterans who are diagnosed with substance use disorder. They are managed by a multidisciplinary team, just like adult healing to wellness courts, but they specifically cater to Native veterans. And healing to wellness courts and their variations are expanding as tribes' needs are also expanding. We can go to the next slide. And Kat, you can go ahead and take it away.
Thank you, Grace. And I will be talking about the future of healing to wellness courts with intergovernmental collaboration. So innovative collaborations between tribal healing to wellness courts and state courts have enhanced each sovereignty's capacity to serve, producing a healing community that is stronger than the sum of its parts. Like the wellness court model, intergovernmental collaborations have developed organically through innovations that meet the needs and context of the courts and their respective communities. And as a result, there have been many different existing collaborations that take many different forms. And one of those forms is the joint jurisdiction court model, which I will discuss briefly today, but we will have a more in-depth discussion during our Joint Jurisdiction 101 webinar as part of this series on Friday. So what is the joint jurisdictional court? Joint jurisdictional court or joint jurisdiction is exercised when a tribal court judge and a state or federal court judge exercise their respective authorities simultaneously, bringing together justice system partners to promote healing and protect public safety. The joint exercise of jurisdiction allows the systems to leverage resources, reduce administrative costs, and effectively deliver services that are culturally based while achieving better results for individuals involved in the civil and criminal justice system. And in a joint jurisdictional court, a state federal court judge and a tribal court judge preside together over a docket that provides tribal and non-tribal individuals, and in some cases their families, with a court supervised alternative that is trauma-informed and emphasizes community values and culture. Many joint jurisdiction courts have taken up the various healing to wellness court models that Grace discussed, but some have created models even outside of the healing to wellness court model. So why a joint jurisdiction court? And even when tribal, state, and federal and local government entities work cooperatively to address shared community concerns, these complicated systems of legal jurisdiction and overlapping service delivery areas that operate within those systems pose a challenge to both those who provide justice and those trying to access it. And then questions about which court has jurisdiction can delay proceedings, and independent parallel justice systems can issue conflicting orders that then need to be untangled. And services provided by one government entity might not be well known within another entity. And in addition, services offered by different government entities may be duplicative, or litigants may play one system against another, thus resulting in an inefficient and ineffective use of resources. And an effective culturally based justice system that has court-connected services and resources may not be easily accessible in tribal, federal, and state systems. So rather than focusing on the problem of complicated jurisdiction in a yours versus mine or all or nothing approach, some judicial leaders have instead focused on developing solutions that acknowledge the autonomy of each. And on a systems level, joint jurisdiction can provide a better understanding about our systems, our families, our people, and how we can approach problems together to create better outcomes for everyone. And on a case level, More reliable and relevant information about each case means better decisions from the court and better outcomes for participants. So let's talk about the first joint jurisdictional court. So the first joint jurisdictional courts were developed by the judges of the Leech Lake Band of Ojibwe Tribal Court and Minnesota's 9th Judicial District, the Cass County District Court in 2007. And then the following year, the Itasca County District Court in 2008 developed their joint jurisdiction court as well with the Leech Lake Band of Ojibwe Tribal Court. And they were both based on the Healing to Wellness Court model. And these wellness courts started as any new drug court would. The only difference was that the two judges exercised their jurisdiction simultaneously, and the wellness court team consisted of representatives from both jurisdictions. So the judges of the tribal court and state court entered into a simply worded joint powers agreement initially, and then they created a more detailed memorandum of agreement and a manual containing policies and procedures that were developed for the day-to-day core operations. And resolutions were then passed in support by both the Tribal Council and the Board of Commissioners for Cass and Itasca County. And these original courts have remained in continuous operation since their inception, despite turnover in presiding judges and changes in tribal and local government. And their work has been so successful that the model is increasingly being recognized and incorporated in many courts. And currently, there are 10 operational joint jurisdiction courts, and interest in the joint jurisdictional court model continues to grow. And we are actually going to be so honored to have the Honorable Corey Wawasik be our presenter on Friday, who was formerly the tribal judge for the Leech Lake Tribal Court, and she played a major part in the development of the first joint jurisdictional court. So if you'd like to learn more about the joint jurisdictional court model and the first joint jurisdictional courts, please attend the Friday webinar, which is going to be more in depth and going to be from the perspective of the Honorable Corey Wawasik. And also for more information about the operational joint jurisdictional courts, TLPI did create a joint jurisdictional court needs assessment that we released in February of 2002, which discusses some of the challenges and the strengths that the current operational joint jurisdictional courts have identified, and some of the needs that they've identified based on their models and the work that they've been doing, as well as the Tribal Healing to Wellness Court Intergovernmental Collaborations publication. That publication is a recent publication from TLPI's Tribal Healing to Wellness Court project that goes in depth about the different intergovernmental collaboration models beyond the joint jurisdictional court model as well. And the Tribal Healing to Wellness Court project is one of the projects of TLPI, but TLPI also has the Tribal State Collaboration Project that has a website called Walking on Common Ground that discusses tribal state collaboration and beyond tribal state collaboration, intergovernmental collaborations more generally, and has a detailed directory of some of the memorandums of agreement or joint powers agreements that some of these courts have in place as a model for other courts who are interested in expanding intergovernmental collaboration or joint jurisdictional courts. And that is my brief overview of some of the futures or the direction that some of the Healing to Wellness courts are currently taking, and how that model has just developed over time and expanded to include these models beyond the traditional Healing to Wellness court models that we discussed earlier. And with that, I can pass it back over to Grace. Thank you. Next slide.
So that was our presentation today, and we would love to open it up to you all if you have any questions. I believe you all can ask it in the chat and or Q&A. Perfect.
And I will be sharing some of the resources I shared in the chat as well for anyone interested in the Joint Jurisdictional Court Needs Assessment or the publication on intergovernmental collaboration.
Okay, well, if there are no more questions, if you're in the middle of typing a question, oh, we do have a hand raised. We do have a question. Let's see.
I can allow Sue to talk and then she can ask her question aloud to you.
My name is Sue, and I represent the Pasquayaqui tribe. We are in the process of thinking of opening up Healing to Wellness Court program to those who are in the medication-assisted programs. Do any of the tribes have any policies, procedures that they would like to share related to this current population? We see an uprise in fentanyl and opioid use and would like some guidance on this.
Hi, Sue. Thank you for your question. As I mentioned at the start, we do have a mentor program through the Tribal Law and Policy Institute that has 3 mentor tribes that all have medically assisted treatment programs and policies that adhere to best practices. So that would be Tulalip, and then the Metro New Mexican Court, and the Little Traverse Bay Bands of Odawa Indians. So if you wanted to provide your email and have some coordination with those courts, they would be happy to assist with reviews of their policies and procedures in that area.
How do I enable my chat?
Kelsey, that is a tech question. I'll turn that over to you.
There is a button on the bottom of your menu bar that says chat. If you click on it, there should be a window that pops up on your right-hand side that says webinar chat. You can also use the Q&A button if you have a question that you'd like to ask as well. And we do have one question in the Q&A right now from Andrea saying, great presentation. I'm interested to know a little more about the veterans courts you are aware of. Where are they and how do they function in terms of different dockets that the court may have besides them? Grace, did you want to answer that, or anyone from the team?
Yeah, we do have a webinar. I think it's on Wednesday. Correct me if I'm wrong, on veteran healing to wellness courts. And then I'm also going to put a little link in the chat. Hopefully this goes to everybody. With a webinar we've done on the past on veteran healing to wellness courts. We had a veterans panel and it kind of discussed the basics of that. And so I would point you there as some resources to maybe get some of those questions answered. I don't know. Okay.
I would also add that there are currently some tribes that are interested in developing a standalone veteran healing to wellness court. I know UROC has explored that idea as well. There is a lot of funding for veteran healing to wellness courts. However, there isn't a tribe that has an up and running healing to wellness court yet that's specifically for veterans. I believe they're still in the hiring process for court coordinators for that model. There are some tribes that have thought about incorporating as a track. But definitely we're going to explore some of those approaches and different models that are currently in place during the webinar.
Thank you, Sue, for sending your email address. We have that there, and if we can just note that, we'll get some information to you on the medication-assisted treatment programs. Are there any other questions? And Wednesday is the veterans webinar, Grace, you were correct on that. Okay, there's no more questions. If you're typing, feel free to finish typing that. We'll see it come up when you're ready, but if we can go to the next slide. Thank you. So here's our contact information. You can go to wellnesscourts.org for Tribal Law and Policy Institute on our Tribal Healing to Wellness Courts site and get further information there. There's also the email address, wellness@tlpi.org, where you can submit a question if you think of one after this webinar, or just need some further information on something that you heard today. Feel free to email us there and our team will respond. Thank you. It's now put in the chat. If you can go to the next slide. That concludes our webinar for today. I just wanted to remind you that if you are needing CLE credits, there's a sign-in link. Is that in the chat, Chelsea?
Yeah, I'll put it in the chat.
Okay, so just be sure to sign in on that link there so that we can mark your attendance and you can have the CLE credit at the end of the week. Next slide, please. Is there an evaluation link? There it is. So if you could scan this QR code, or there will also be an evaluation link in the chat box. So you can let us know if you enjoyed the webinar today, if there's further information that you might need, any comments or suggestions. We'd love the feedback. We'd love to hear from you and help make our future, thank you, the link is now in the chat, help make our future webinars exactly what you would like it to be. Thank you everybody for joining us for our Tribal Healing to Wellness Courts History and Evolution webinar for today. I look forward to seeing you tomorrow, same place, same time for our next topic. Thanks everyone.